Ladies and gentlemen, our talk this morning is going to now be continued by Felicity Bentley. Felicity was admitted to practice in December 2008 and signed the bar roll in 2010. I might say, and I'm sure it'll be in his paper, but Adrian at one stage talking about the date in which the new legislation had come into effect for office. I think you mentioned the year 2010, which was rather than 2014.
2013 for the Supreme and County Courts and 2014 for the Magistrates Court.
Yes. So that's important, I think. Now, Felicity has a broad commercial practice, which includes equity and trusts, corporations and securities, including directors' duties, insolvency, including winding up applications, creditors' petitions, application to set aside statutory demands, liquidators' examinations and associated hearings, property trade practices, wills and estates, and she appears regularly in the Federal Circuit, Supreme and County Courts. And so, Felicity, over to you.
Good morning. Thank you all for coming out so early on a cold winter's morning. Adrian's talked to you all about the changes, which I think are quite significant. And arguably will have the effect of reducing the number of Calderbanks, or at least should have the effect of reducing the number of Calderbanks that are used. In terms of what I've seen in my practice, it seems that practitioners have a preference for Calderbanks. I'm not sure why that is, but certainly that's what I see most often. Calderbanks will still have a place, but I think that place will be limited by the changes. The topic of Calderbanks and offers of compromise is a huge topic. Arguably, there's some kind of offer of settlement made in every piece of litigation. So this is something that comes up all the time. There are a lot of cases on it, almost weekly. So it's a difficult topic to give you sort of interesting and new information. So what I propose to do today is just a bit of a refresher on how to draft a good offer and what to be mindful of. And then also some unusual situations, including whether or not you can use a Calderbank in VCAT, what to do if your claim is predominantly or solely a non-monetary claim, such as a claim for an injunction or a declaration. And if we get time, and as a barrister, I'm notoriously bad at estimating time, so if we get time, I wanted to throw out an idea, some ideas about whether or not you might be able to use offers of compromise in a few unusual situations, and maybe get the room's thoughts on this, because it's certainly there are some interesting areas of law where people don't tend to use Calderbanks or offers of compromise, and perhaps should moving forward. So in terms of talking about some structuring and drafting tips, now some of these might seem like fairly obvious or condescending points, but forgive me because I do see a lot of Calderbanks that are poorly drafted. It seems that people often use Calderbanks just as a matter of course. Just, I'm running a piece of litigation, quick, let's throw down an offer, slap together a Calderbank using a precedent, and then move on. But this shouldn't be happening because it is an extremely valuable tool. And it can potentially save your client tens of thousands of dollars in legal costs. So it's worth actually thinking about and focusing on and turning your mind to the issues that Adrian's talked about in terms of end game and things like that. To give an example, I recently ran a fairly lengthy trial in the lovely Dandenong Magistrates Court where a Calderbank had been made and it was well drafted. The ultimate result was that we got our costs on an indemnity basis, which ended up being $45,000. On scale, I worked out those costs would have been about $16,000. So somebody turning their mind to writing a comprehensive Calderbank early on resulted in an enormous benefit for the client. So in drafting, what do we put in the content? In terms of the offers of compromise, make sure you read the rules. It seems obvious, but as Adrian said, if it doesn't comply with the rules, it just won't cut it. In terms of a Calderbank, this is your chance to be persuasive. Why does your client have a good case? It's a good opportunity to turn your mind to why your client has a good case, to focus you early on, and to persuade the other side, because ultimately the point of an offer of compromise is to settle the proceeding. People don't seem to think about that. They think it's about cost protection later down the track because, hey, nobody will accept it. But the point of it is to end the proceeding there. So make it persuasive. And be detailed. So don't leave any areas open for ambiguity, because that's one of the areas in which your Calderbank will fall down. And try and avoid your offers being unnecessarily complex or convoluted, because that also creates avenues for ambiguity. Think about the question, is this offer clear and capable of being accepted? And as Adrian said, it's the sort of thing where if the other party accepts, it creates an immediate binding relationship on those terms. So there can't be anything else that needs to be done. And then the final question is reasonableness. And that's the main thing the court considers when it thinks about whether or not this offer should have been accepted. Think about, is my offer reasonable? Is this a genuine compromise? Or am I just discounting my claim by $1 to get my client cost protection? That's something that you are allowed to do. But think about, is it worth it? Or can we move a little bit further and make this more reasonable? And set out why it would be unreasonable for them to refuse the offer, because that ultimately is what your counsel or you are going to make the argument about at the end. A fairly recent case in the Court of Appeal of the ACT sets out a good example of what could have been a fairly simple offer in a fairly simple scenario that was so poorly drafted that it fell down. Here is the offer that was made. As you'll see, the plaintiff offers to accept a sum of money, but then goes on to say, plus interest at 20% in accordance with clause 21 of the contract until that money is paid. The clause of the contract dealt with payments being late and allowed for charging interest at 20% on late payments. So arguably you could turn to the contract and work out what that meant. However, what the master found at first instance, which was supported on appeal, is that paragraph 2 of that offer, to do with the interest, was capable of more than one interpretation. When did that interest start to run? When did it end? Did it end on the date of judgment, at which point it reverted to penalty interest or statutory interest? Or did it intend to apply until that judgment was paid? In doing so, the court noted that the terms of the settlement offered must be unambiguously clear and the offer must be capable of being accepted. In this case, they found that because of the two possible interpretations of the interest component, the offer was not able to be accepted because it was unclear. So if you want to include interest in your case, make sure you specify what that rate of interest is, the amount on which the interest is to be charged, the type of interest you're going to charge, and the start date and the end date for calculation. This is a time you need to be detailed if you want to make it that complicated. Costs. This is something Adrian's been talking about, and I think this is one of the main areas where offers fall down. Confusing offers to do with costs. Again, in this Kemp and Ryan case, perhaps if we go back to the offer, at paragraph 3, the offer says, plus costs as agreed or assessed. Now, in Kemp and Ryan, the judge says, I would have had no difficulty in reading paragraph 3 of the offer as limited to party and party costs, but the addition of the final paragraph adds some confusion. And if we go back again, the final paragraph is, we advise that our solicitor client costs are X to date. So then it begs the question, on what basis are they intending to charge costs? And that in itself creates an ambiguity, which caused the offer to fail. Do you need to include costs? It's up to you. You can make an all-in offer. As Adrian's mentioned, in terms of making an all-in offer, there is the risk that it is more difficult for the court to assess whether or not that was reasonable at the time it was made. But the advantage on the other side is that it's generally easier for the recipient client to assess whether or not they want to accept the offer. I'm sure we've all been in the situation where you've said to your client they've offered to accept $50,000 plus costs, the first question is always, what's the cost? And that puts you in a difficult position because you might have to estimate what their costs will be at that time to assist your client in whether or not they should accept the offer. So if there's an all-in offer, it helps everyone know exactly what position they're going to be in. So there's an advantage and a disadvantage. You've just got to work out in your case what works. But if you are going to include costs, always be clear as to whether your sum is inclusive or exclusive of costs. And be careful to specify the amount of the costs and whether those costs are to be agreed or taxed, and the basis of the cost assessment, which is where that Kemp and Ryan matter fell down.
If you made an offer which was, say, $100,000 plus $10,000 in costs, you get to the end of the hearing and you only get $80,000 in judgment, but it turns out your costs on party and party that time were $50,000. So even though you have gotten less in terms of the judgment, because you were under-quoted or undercut your costs claim, you've actually beaten your offer. Do you see any difficulty with that counting as beating?
I think it would create an argument. Certainly the argument would be a lot longer, but I think you'd still have a position to argue that the overall thing that you offered was decent. I don't know if Simon or Adrian have any thoughts on that idea.
I think there'd be an argument because I think that there's always been a division between the quantum of the claim and the costs. And the simple answer is you'd have failed on the quantum of the claim part of it, and the fact that you'd offered to take a figure for costs of something less. I think my sense of it is that the offer would be ineffective in those circumstances, I think.
To deal with the other things you might want to or need to include, you always need a time frame for the acceptance. In a situation with Calderbank, the advantage is there's no specified time that the offer must remain open for. Again, it's just a matter of reasonableness. If you're coming up to trial, you might be under the pump, so you might have to lead a shorter time frame. But if it's early on, be as reasonable as possible. Give the other time as much time to think about it as they might need, depending on the complexity of the issues. In terms of an offer of compromise, the time frame is dictated somewhat by the rules as being not less than 14 days. Then on the issue of what Simon touched on, being whether or not you need to state the consequences of the non-acceptance of the offer. There seems to be mixed views by the courts, and I think it does ultimately depend on the actual facts of the case, as Simon has talked about. But if that's what you intend to do, there's no harm in saying it, and perhaps you'd err on that side, given the mixed views on the issue. To move on to some slightly more unusual situations, and situations that I think are coming up more and more, cases where there are multiple defendants. How can a plaintiff make an offer to multiple defendants? It can happen, but you do need to be really careful in making the offer to make sure that offer is capable of being accepted. And in doing so, you have to think about what is the liability of each of the defendants. What is the type of liability? And it's, as Adrian mentioned, look at the Wrongs Act provisions and in terms of contribution, indemnity, apportionment. Are the interests of the defendants aligned or do they differ? A fairly recent case of the New South Wales Court of Appeal shows that in making offers to multiple defendants, you can make a pretty serious mistake. In this case, there was an offer made to the first defendant and the third to seventh defendant, and the wording was to compromise the action in the whole on the terms that those defendants together paid the settlement sum. The court found that that offer was not capable of being accepted by the recipient of the offer, in the case of the first defendant, because the first defendant couldn't bind the other defendants and say, yeah, sure, we all accept, without authority to do so. And the interests of the first defendant was different to the interests of the third to seventh defendant. So it wasn't unreasonable for them to reject the offer. So just be careful if you are making offers to multiple defendants, that you word it in such a way that that defendant, having regard to their rights, in terms of rights to contribution and so on, that they can accept it in the circumstances. The rules deal with offers of compromise in relation to situations where there are multiple defendants, and the issue to do with dismissing a claim where an offer is made and then the settlement sum isn't paid also has a a component that deals with multiple defendants. I won't sit here and read out the rules, but it's worth checking out those provisions if you're intending to make an offer of settlement in situations where there are multiple defendants. It is a tricky area. Contribution, indemnity and apportionment just generally is a difficult area, and if it's something that you're struggling with, it's worth possibly running it by counsel before you draft the offer, because they're the ones who are going to have to argue it in the end. Adrian touched on the issue of an offer to contribute. This is also a very useful tool to protect your client if your client is a defendant who's claiming contribution from another defendant or a third party who might have a joint liability. It helps when this doesn't just apply to offers of compromise, it also can apply in a Calderbank or more general offer of settlement scenario. To give an example, a fairly basic example, this is probably about as basic as it's ever going to get. You've got a plaintiff who says, I'll take $100,000 in satisfaction of my claim. Defendant 1 says, that sounds fantastic, I'd love to take it, I want to pay $50,000. Defendant 2 says, no, that sounds terrible, I only want to pay $30,000. Obviously they can't settle on that basis, but defendant 1 can give to defendant 2 an offer to contribute for $50,000 and say, on the basis that we've been offered 100, I'll pay half. That's the gist of it. They can do that under the rules, under Rule 2610, or just via an offer, a Calderbank offer. At trial, let's say the plaintiff is awarded $80,000 and defendant number 1 is found to be liable for 50%, or even less than 50%. In that situation, defendant 1 can seek to recover from defendant 2 all of its costs, together with any of the plaintiff's costs it's ordered to pay. That's a huge advantage for your client as a defendant. What about the issue of making more than one offer within a case? It's a matter of strategy, and it's entirely up to you and the background to the case. I tend to see people only making one offer. I don't know why this is. I don't know whether people think, oh, well, I made one written offer, then we went to mediation, none of them have worked. Oh, well. Certainly the rules don't prohibit you from making more than one offer, and it's quite obvious that you can make more than one Calderbank offer. They can be the same offer, or they can be a different offer. Making multiple offers within a proceeding should be considered, because it may be reasonable for a party to refuse an offer at some stage, for instance, a pre-issuing offer, as Adrian's mentioned, that are available, but not reasonable at a later stage. This will change in terms of how much cost has been spent in the litigation, different issues that have been ventilated, a narrowing of issues and so on. So it's worth considering, is our position now different, and would it now be unreasonable for them to accept this offer? I'll just briefly touch on some unusual circumstances. And the question that's starting to come up more and more is, can I use a Calderbank in VCAT? The reason this is relevant is it's seeming that VCAT has an ever-expanding jurisdiction. Trials are now being set down for lengthy times. They're dealing with huge sums of money. I recently had a VCAT matter set down for 10 days. That's going to be a very expensive hearing. Gone are the days where it was meant to be about, a $5,000 dispute that'll take 20 minutes. So now cost protection in VCAT is critical. Can you use Calderbank in VCAT? The default rule, as everyone would know in VCAT, is that each bear their own costs, and any other order is a matter of the discretion of the tribunal. A recent decision of Associate Justice Daly and Hopkins addresses the use of Calderbanks in VCAT. And the question predominantly is whether or not the statutory regime that's set out in the VCAT Act, which in some ways is reflective of the Supreme Court Order 26 provisions, whether that covers the field or whether there's still room for Calderbank offers. Associate Justice Daly's analysis demonstrates that this is entirely unsettled, and VCAT tribunal members seem to have very mixed views on the issue. I've mentioned 2 cases which are up on the PowerPoint. The first one basically says that in light of how comprehensive the regime is, it seems that Calderbanks are entirely unnecessary and shouldn't apply. In the second case, there's a consideration that maybe this is just something to be factored in to the Section 109 considerations. Ultimately, Associate Justice Daly says it still remains open, and it will be decided in varying ways. And that brings up the second question: should you use a Calderbank in VCAT? In light of the above, I would say no. If I had to give advice on it, arguably it's better to rely on the fairly comprehensive statutory regime for cost protection under the VCAT Act, which is set out in sections 112 to 114. Again, if you're drafting an offer under these sections, read the sections, make sure it complies. The section allows for all costs to be paid. Now, what all costs are is yet to be defined, and again, as with the wonderful tribunal, there's very mixed views on it. However, there seems to be a trend towards the fact that all costs are full indemnity costs. So if you use the statutory regime in VCAT, you get this full protection, arguably. So why would you use a Calderbank? I can't see any decent reasons to. Calderbanks are useful if you want to argue your position, but there's nothing stopping you from doing that in a VCAT statutory offer. You can send it under a cover letter if you want, setting out why you're going to win and why they should accept your offer. One of the final unusual circumstances is non-monetary claims. I don't see many offers made in situations where there are non-monetary claims, and maybe that's because it's just more difficult. It can be difficult for a court to assess whether or not there has been a more or less favourable outcome, because when it comes to things like declarations, it's hard to say what's better and what's worse. You don't have, oh, well, there's 10 and that's 20, so that's obvious. It's also more dangerous that the offer isn't clear and capable of being accepted, because generally they're more complex offers. But it doesn't mean you can't use them and that you shouldn't use them. You just need to think about it, be a little bit creative. Think about, am I compromising the claim? Is there a genuine, am I giving something? Is it a genuine compromise? There's a great case of My Environment Inc. and Vic Forests, where the plaintiffs sought to restrain the defendant from timber harvesting and to obtain a declaration as to the unlawfulness of that timber harvesting, but the plaintiff was unsuccessful. The defendant sought the costs on an indemnity basis, having made a settlement offer very early on in the proceeding. Now, the court didn't ultimately award costs on an indemnity basis for other reasons, but the court did note that the offer was entirely reasonable and it demonstrated a significant restriction of the areas that they proposed to be harvested. So it was pulling back a little bit and saying, here's the compromise. As Adrian noted, this is another one of the situations where the letter of offer is attached to the judgment. I would encourage you to actually look at it. If you're thinking about making an offer of compromise or a Calderbank in a non-monetary situation, have a look at this letter that's attached here, because I think it sets out brilliantly a way to set out what you could have asked for, what you're asking for now, and why that's reasonable in all the circumstances. This is the final issue I wanted to touch on because we're running out of time. And this is not something I intend to talk to you about, but just something for you to think about. And maybe there might be some people in the room who've had experiences with any of these. How do you compromise a class action or representative proceeding? This is something that's coming up more and more. It's becoming extremely popular in terms of shareholder class actions and also to do with banks recently. Obviously, you've got the bushfire matters. How do you compromise a matter when there's a number of unknown plaintiffs for the court? There's been one judgment that's talked about this issue, and it touches on the idea of dividing the issue of liability and quantum and making an offer to accept liability in some circumstances, and that might be a situation where you could trigger cost consequences. These are often enormous proceedings, and it's worth thinking about how we can protect the clients from a cost perspective. And the other issue is, and I'm not sure if there's many people in the room who practice in this area, but recently I was in a mediation in a Part 4 TFM claim, and somebody said, oh, you can't use Calderbanks in this. The rule is the estate pays the cost. That's it. And two fairly senior counsel began arguing about it. Not many of these matters get to trial. So this issue hasn't been discussed in depth. But there is a push to change the costs rules in relation to TFM, and maybe it is worth considering making offers of compromise and Calderbank. There's nothing to say you can't, they are made, but again, it's a matter of considering what the rules allow for and how you can be creative in that sphere. If anyone has any experience in any of that and want to talk about it, I'd be interested to hear it. But other than that, I think we'll open it up for questions for anyone on the panel. Thank you.
All right, well, thank you very much on behalf of Michael Green. On behalf of Michael Green and his team, I want to thank you all for coming. I particularly want to thank Adrian and Felicity, who I think speak very highly of the quality of commercial juniors on Green's list. It's important that the relationship between the bar and the legal and the solicitor side of the profession be maintained, and we hope that the goodwill engendered by these breakfasts achieves that and helps you as well. Thank you very much.